seated in the courtroom. Everybody is ready to break. We're ready to continue. Begin with the cross-examination of Dr. Danzinger. You may proceed with order.
Good afternoon, Dr. Mr. Wood. Good afternoon to you, sir. Now, let me kind of go for the moment from the reverse order, going towards the tail end of your direct examination. We're talking about Dr. Kropp and his evaluation of Mr. Colley, his involvement in this case. I believe you said that you received his evaluation of this case dated December 30th of 2015, is that correct?
Yes.
Okay. And in that letter, or that report to Mr. Shoemaker, Terry Shoemaker, in the first paragraph of that report, Dr. Kropp says that he's providing a summary of his impressions in the case, is that correct?
Yes.
Okay. So, and then further into the that report, Dr. Kropp gives an opinion that he believes that Mr. Colley is competent to proceed. Is that correct?
Yes.
Okay. Now, in that same paragraph, in that same report, he does also say, however, given the various medications he was taking, I would recommend that a psychopharmacologist review the defendant's drug use around the time in question. Is that correct?
Yes, which indeed happened
here. And have you, in your prior history as a psychiatrist, consulted with pharmacologists or psychopharmacologists?
Yes.
And is that something that's characterized as something that's fairly often done in your practice, or how would you characterize it?
If there's an issue, for example, regarding to urine or blood testing, which was not a factor in this case, but then it's helpful to talk to a toxicologist or pharmacologist. If there's a question of interpreting autopsy results, for example, that's usually not something a psychiatrist would do. If there's something involving the metabolism of drugs or very rare drug effects, then it might help to talk to someone who's a pharmacologist or toxicologist. So not in every case that I've done do I consult on that. And in my day-to-day practice as a treating doctor prescribing medications, I don't call up a pharmacologist. I mean, I understand enough as a practical day-to-day doctor how to prescribe these drugs, what the side effects are, but there are situations where it helps to have a consult.
From your review of this report, are you left with the impression that Dr. Kropp is indicating that he'd like to have additional materials to be able to review in the future in his involvement in the case?
Well, my impression was my own, that he got a full account of what happened after court, and he's saying that the issue of drug effect is not something I do, maybe drug effect on Mr. Colley, and my recommendation to Mr. Shoemaker, the lawyer, is get someone else to look at that. That's my reading of it. Of course, I'm not Dr. Kropp, but that's how I understood what he wrote.
As your involvement in this case, or during your involvement in this case, did you ever consult with Dr. Kropp regarding this case?
No, I did not.
Do you have any idea how long Mr. Colley spent with Dr. Kropp?
I don't.
Okay. Obviously, you were not present when this consult or evaluation was done with Dr. Kropp.
No, I had no knowledge of this matter in November or December 2015. Not at all.
Now, from your review of the report of the writing, the document from Dr. Kropp to Mr. Shoemaker, the focus is competency to proceed to trial. As you say, that's issues of whether the person has a mental defect, which prevents them under the legal standard from being able to assist their lawyer in their own defense.
Well, not quite, because Dr. Kropp also addressed sanity and said that Mr. Colley could appreciate the nature, quality, and wrongfulness of his conduct. So he addressed both competency and sanity.
Are you aware of any testing that Dr. Kropp did on Mr. Colley?
No.
Okay, all right. And do you know, would you have any way of knowing if Dr. Kropp's practice in conducting competency evaluations are shorter or longer, more involved, less involved, than if they're in evaluation for insanity at the time of the offense? Would you have any way of knowing that?
I don't know how Dr. Kropp does. I don't know how I do it, but that there's two factors. First, some cases are more complex than others. Secondly, a capital murder case probably takes more time than a trespassing case because the stakes are higher and there's often more information to sort through. So some people are more talkative than others. So there's different factors that affect how long it takes. But typically, my understanding of Dr. Kropp, and he can speak for himself, but it appears to me he looked at the issue of what is Mr. Colley's competency, his current mental state as I talked to him 3 months after the offense, and what was his mental state like at the time in August. So it looks like Dr. Kropp addressed both.
And this was the only report, only document referencing a consult that Dr. Kropp had with Mr. Colley.
It was, but again, the key thing was there was no reference to memory impairment, blackouts, or fogs. There was no reference to that. Dr. Kropp simply said he described the events after court.
When you were retained in this case, what is your hourly rate?
For this case, I cut it in half. It is $300 an hour.
So normally it would be $600, it's $300 an hour for this case.
Correct.
Is that because you're being retained by the state attorney's office?
No. If I'd been retained by a public defender, I would have done the same thing. So if it's the public purse, I usually cut my rates at least in half.
Okay. And do you know...
You are not a public defender.
That's correct. Do you know thus far how much you charged the public purse for your involvement in this case?
So far, the bills that have gone out are about $7,400. Of course, I did some preparation time last night, and then I've been here today, so that will add to that.
All right. Now, in your practice, your psychiatric practice, have you had, certainly you've had patients in the past that have expressed issues, problems, if you will, with side effects of the medication that they're on?
And the answer is yes. You're a doctor in practice. You prescribe medications. Some of these medications have common side effects, so yes. And in fact, if I see patients in follow-up, if I prescribe something, the first time I see them, I ask about the effect and any problems with the medication. So I actually ask if they're having side effects. And sometimes people will call me after starting a medication saying they're having an issue or a problem. So yes, it's very common in day-to-day practice.
And have there been occasions when you've had to adjust medication? And when I say adjust, either take him off that medication, put him on a new medication, or change the dosage in any way?
And the answer is routinely. That's a very common thing in practice.
Okay. And have you done that type of practice or habit in with regard to antidepressants?
Yes. One of the major classes of medications psychiatrists prescribe are antidepressants because they treat depression and anxiety, which is what drives most people to my drug.
And you were able to hear Dr. Buffington's testimony with regards to his testimony regarding the effectiveness, say, for Wellbutrin, that it takes a while for that prescription to reach its peak effectiveness over time once taken.
I listened, but I have some disagreements with his analysis.
Now, and he also spoke about Cymbalta. Is Cymbalta a more potent drug than Wellbutrin?
No. Each antidepressant is equally effective in the treatment of depression. None of the antidepressants we have are more powerful than one another. They may work for different people. Some medicines better for others. Their side effect profile may differ. But to date, we don't have an antidepressant that's our most powerful or better one. They all seem to be equally effective, although they may work for different people.
And you're aware of the side effects adverse side effects for antidepressants?
I'm sorry?
Are you familiar with the adverse side effects for Wellbutrin and Cymbalta?
Yes, these are medications that I actually was a principal investigator on before they even came out on the market. I've used Wellbutrin since 1988, before it was approved. Cymbalta, duloxetine, since the mid-90s, before it was approved. I've prescribed these medications to hundreds of patients, written thousands of prescriptions because some patients stay on it and need further prescriptions. These are very commonly used medications that I've prescribed thousands of times.
And you reviewed, during the course of this case, the listed side effects, adverse side effects that Dr. Buffington related in his materials about Ambien?
Yes, and again, I prescribed Ambien, which came to the market in 1990, 28 years ago. So I'm very familiar with Ambien. I've written prescriptions for it. I have patients who take it. So I'm familiar with the side effects, not just from what Dr. Buffington wrote, but because as a doctor, I've been writing it for almost 3 decades.
And you don't have any disagreement with Dr. Buffington's documentation as to the listed known adverse side effects of Ambien?
Not the known side effects, but its relationship to this case. That is the distinction. I agree those side effects can happen. I disagree it happened here.
So in the testimony, and to extend that question out, with regard to the adverse side effects that Dr. Buffington testified to in this case here today, you don't disagree with the testimony as to the adverse side effects?
I don't disagree with the hypothetical or possible side effects you can see. If you put, as we do in our studies, thousands of people on this medication, and then you see how many people had headaches, how many people were sleepy, how many people were coughing, how many people had diarrhea. So you put thousands of people on it in the studies and you have the percentages. So there are more common and rarer side effects. I don't disagree with the side effects he listed, but just because it's listed and it may occur at 1 or 2% in thousands of people, it doesn't mean it occurs in this particular person. And our disagreement is whether it happened in Mr. Colley's case. I say it didn't.
Now, you're aware of the literature and the research with regard to adverse side effects of Ambien, are you not?
In general, yes. I can't cite a specific paper, but yes, I prescribe Ambien. I'm aware of the side effects. When I prescribe it for a patient the first time, I give them informed consent saying these are the potential side effects. If this happens, call me and stop taking it. So yes, I discuss this with patients the first time I put them on it, what to expect, what problems they might have it, when to call me and not take it anymore. So that's just part of the day-to-day being a doctor practice.
And I think you alluded to it a little while ago, but you're aware of, in the literature and the research, of situations where persons have completed complex tasks driving other types of activities while they're experiencing the adverse side effects of Ambien, correct?
Driving, but usually driving poorly and being confused when spoken to. So they may engage in a task like cooking or driving, but they are not fully coherent and organized. There's a distinction. But you're correct that they can drive, but often drive poorly.
The parasomnia that was described earlier today, and defined here today by Dr. Buffington, and actually, well, you were here yesterday, it's an unfair question. Do you have any disagreement with Dr. Buffington's definition and description of what parasomnia is?
I don't recall exactly what he said, but I know a parasomnia can be described as some unusual event or experience during sleep.
And do you know that parasomnia also to involve memory loss?
Yes, and there's many parasomnias: sleepwalking, sleep terrors, REM sleep disorders, exploding head syndrome. There's all sorts, sleep paralysis, there's all sorts of parasomnias. Some of them people remember, some of them they don't.
Do you, let me go back to something you said kind of in the earlier stages of your direct testimony, which was one of the things that you took into consideration with regard to the issue of impairment is that Mr. Colley, on the days prior to the weeks, consisting of the week prior to the shootings in this case, that Mr. Colley went to work and there was no reported adverse effects with regard to the medication during that week prior to the homicide. Did I succinctly state that's what you talked about?
More or less, and that was in response to Dr. Buffington talking about the changes in antidepressants producing problems, and my response was he was going to work, he was coaching t-ball, he was enjoying birthday parties, doing recreational things. So whatever changes were made in the antidepressants did not appear to affect his day-to-day behavior in the days and weeks before.
And did you ask Mr. Colley when you did your in-person evaluation with him whether or not he had been taking Ambien on the days or any specific day prior to the morning of August the 27th, during that week time frame before the murder?
I don't believe I asked that question.
Okay. So now I think you said this in direct, you did receive Mr. Colley's pharmacy records and medical records, is that correct?
Yes, well, I received some pharmacy records and I received some medical records. So when you say that, I don't know if I had every single record, but I certainly had some medical records.
And to clarify, you did have pharmacy records indicating that Mr. Colley was in fact prescribed Ambien and antidepressants in August of 2015.
Yes, on August 10, prescribed by Dr. Sanchez and then picked up at the pharmacy. Exactly what he took, I don't know, but they were prescribed and he got them at a pharmacy. That's correct.
Okay. So you have no issue about whether or not Mr. Colley was in fact prescribed Ambien or the other medications?
That seems to be very clear, and there's no dispute on that point.
Okay. Now, are you familiar with the, forgive me, it's a layperson asking a psychiatrist a technical question. How long does the psychoaffective, how long does Ambien last in your system as far as having effects on the mind? I'm talking about blood tests, if we were to do, like with cocaine, if you were to do a blood draw or something like that. But how long does Ambien stay in your system as far as affecting your state of mind?
The average duration of action is about 3 hours. Now, that's if you take the immediate release form, not the time release form that slowly dissolves over hours. So if you take an Ambien, it acts fairly quickly, it dissolves fairly quickly, and usually takes effect in 15 minutes. It's got a short half-life, which is the time for your body to eliminate half of it. Half-life's about 2.5, 3 hours. And typically its major effects are within the first 3 hours. So that's why it's good for putting you to sleep. It's not as good for keeping you asleep if your problem is you fall asleep fine, but you're up at 2 or 3 in the morning. So that's why they made a time-release Ambien, the Ambien CR, so you get half of it immediately, and then the rest of it dissolves out over the next several hours to try to keep you asleep. But I'm not talking here about how long you can measure Ambien in the blood or the urine or anything like that. But its effect is fairly short. The major effects are within the first 3 hours.
Wouldn't the effect actually be more in the 8-hour range?
Typically, that goes to the point of why it's good to knock you out. It's good for initial insomnia. It's not as strong for later. So you can still probably detect it, but its major effects are in the first 3 hours.
Does that vary on the individual, or are we all cookie cutters as far as the effect on Ambien on the person?
No, everyone's different. Everyone's liver and kidneys works a little bit differently. Part of the roles of our liver and kidneys is to break down or metabolize medications and eliminate them. So when you take a medication, your body works to eliminate it. So the liver does a lot of that heavy lifting, so do the kidneys, and everyone's a little bit different. Everyone's liver enzymes are a little bit different. Everyone's genetics are different. So how quickly we break down drugs, it varies from person to person. There's averages. Some people are outliers.
Let me ask you this. When you testified about the narrative, your interview with Mr. Colley and his description of the events in question, did during the time that you were with Mr. Colley there at the jail doing your evaluation, did you make the effort to distinguish between what was told to him from others or what he read from other sources versus what he remembered?
Sometimes, for example, in the mailbox, for example, he said he didn't recall hitting the mailbox, but was told that. But when I was speaking with him about his recollections, I was asking him, what do you recall, not what other people told you.
And you didn't,
with the exception of the mailbox, perhaps.
Right. But you didn't do that with every point that you were asking about. Is this what you remember, or is this what somebody told you? And I was there with you. Did you make that distinction when he was reporting to you? Hey, is this something that somebody told you, or this is what you remember?
I know that during his report of what happened after court, I was asking him, what do you remember? That's what I recall. Of course, there was no court reporter there. You were there, and Mr. Shoemaker was there. My effort was at that point, what do you remember? How I specifically asked it, I don't know, but my recollection was, tell me what you remember. And that's why there's things where he said to me, I remember I was standing on the jogging path, and then my memories are blank for a while, and then I'm here, and then there's a blank. So my intention was, what do you recall?
I do not have anything else. Thank you very much.
Mr. Johnson, any redirect examination? Take it on. Is Dr. Danzinger excused? Yes. Dr. You're excused. Dr. Call your name, please. Give me a moment. Yes, sir. Okay. State that you want to round up this next with us. So we'll go ahead and take a short break. I'll have you stay up here if everybody doesn't mind, because this will be very short as opposed to moving you back and forth to the other floor. So let's plan on about 10 minutes at most. And again, don't discuss the case among yourselves. Leave your notes here in the courtroom and get back to this ministry on there. Welcome, everybody. Welcome to be seated in the courtroom. We have our next witness available. So state call your next witness.
State calls Judge Charles Tinlin.
Judge Tinlin, if you can come in. I know I don't tell you where the witness stands.
to be the truth, the whole truth, and nothing but the truth?
I did.
Be seated. Ms. Dunn, you may proceed when you're ready.
Thank you. Good afternoon, Your Honor. If you would, please introduce yourself to the jury.
My name is Charles Tinlin.
And how are you employed, sir?
I'm a county judge here in St. Johns County.
How long have you served as a county judge here in St. Johns County?
I'm in my 28th year.
And what types of cases do you preside over?
I do both a criminal docket and a civil docket. Probably majority criminal, but probably 35% civil.
How many people or cases come before you in your courtroom every year?
Last year, the numbers were about 7,000 cases.
And you said a majority of those are criminal cases?
They are.
In a criminal case, if a defendant wishes to enter a plea, what happens at that time? What do you do?
The defendant will be placed under oath. I'll ask the defendant's name, the defendant's age, occupation. I ask whether they've ever been treated for any mental illness, and I'll ask them if they're now under the influence of any intoxicants. I'll then explain to them that by entering this plea, they are giving up their right to have a trial, to be presumed innocent until proven guilty, to be represented by a lawyer, and if they cannot afford a lawyer, I would appoint one to represent them, that they have a right to cross-examine any witness called by the state to testify against them, to compel the attendance of their own witnesses, to testify or remain silent, and they would be presumed innocent until the state proves their guilt beyond a reasonable doubt. In some cases, there's a little bit more advisements. If it's an enhanceable offense or if they lose their license as a result of entering a plea, there may be some additional admonishments as well.
And what is the purpose of asking a defendant those questions in a criminal case that we're talking about here?
We want to make sure the defendant is giving a free and voluntary plea, that he understands his or her rights to. They're guaranteed by the Constitution, the right to be presumed innocent until proven guilty. They're not being influenced by anything, that they're not under the influence of anything.
And are you looking for anything while you go through that colloquy with the defendant, and do you
Sure.
have to make any determinations at the end?
First of all, I want to make sure that they understand what they're doing. And I also want to make sure that they're not suffering from any kind of incapacity, be it mental incapacity or they're under the influence of anything.
And is this something you do on a daily basis?
Every day.
Have you had experiences in your past 28 years on the bench with persons where you do become concerned for one reason or the other over their ability to understand what's going on?
I had a case today where I was very concerned about the defendant's mental well-being. He was somewhat unresponsive. He wouldn't look at me. He kept looking at the floor. I couldn't get an answer from him. So I asked that he be evaluated by mental health to make sure he's mentally competent to go forward. That's not unusual. I've also had occasions where I believe someone might be under the influence of either drugs or alcohol. If I get an indication, regardless if they tell me or not, I might have them go into a breath test machine or maybe have them take a urine test and determine if they're under the influence of anything. I've had people that have, in fact, blown high blood alcohol level while they're in court while I'm trying to take a plea. And what I'll do, I will remand them to custody possibly, or I'll reset them for another court date.
Now, I want to ask you about a plea that you took from the defendant in this case, James Terry Colley, Jr. Do you recall court appearance with him August 27th of 2015?
I did.
And was that in your morning court docket there a little after 9 a.m., I believe?
That sounds about right.
Was he present with a counsel or an attorney at that appearance?
He was represented by a gentleman named Colley Grant.
Did you go through the colloquy that you just explained to the jurors with Mr. Colley that morning?
I did.
And throughout that process, did you have any concerns over impairment or his ability to understand?
I did not. I asked him if he was under the influence of any intoxicants. He told me he was not. There was no indication, nothing in his demeanor that indicated he was under the influence of anything.
Did you make any observations or findings about him after going through that colloquy?
I made a finding that he was competent to proceed, and I took the plea. His demeanor was fine. I didn't see any indication that he was swaying or not understanding the questions I was asking. He was giving me appropriate responses to the questions I was asking.
He was alert and intelligent and things like that you look for.
In my opinion, he was.
And did he ask you relevant questions throughout the colloquy as well about what was going on?
He did. He seemed, his biggest concern that day was when he could be on probation. I explained to him that upon completion of all the conditions of probation, which would include including a 27-week domestic violence course, he would be terminated from probation if he completed that successfully and paid all his court costs and fines.
Is that something that you get asked a lot by defendants
Sure.
in the similar type plea?
Yeah, people want to know when they can be finished and if they can be off probation early, so they may ask that question, sure.
And Your Honor, prior to court, did you review an audio and video recording of that appearance that we've been talking about here today?
I did. I observed the video that you showed me and also watched one that I had on my computer drive after I found out I was going to be subpoenaed for this trial.
Your Honor, may I approach?
Yeah.
And Your Honor, I'm going to show you what's been previously marked as State's Exhibit E for identification. Do you recognize that disc?
I did. I initialed it today and dated it.
And that's the recording, or at least one recording of the plea colloquy that you took with the defendant on August 27th.
It is.
Your Honor, this time State would admit State's E.
Any objection?
Judge, for the reasons that we previously stated during another session out of the presence of the jury, we maintain our objection. We attended to the matters that we stated on the record previously.
Okay, so noted for the record, the objections are overruled and the item will be admitted into evidence. This is State's next number exhibit.
Your Honor, permission at this time to publish?
You may.
You can call your next case when you're ready. Next case, Judge, is going to be James Terry Colley. Come on, sir. He is charged with violating an injunction. Good morning.
Good morning, sir. I'll ask on behalf of James Colley.
Thank you, sir. And Mr. Veteran, do we have something worked out today?
Yes, sir, I believe we do.
Go ahead, please.
Your Honor, this time Mr. Colley is authorized to enter a plea of no contest, the charge of violation of injunction, with the understanding that his sentence will be a loophole adjudication, 1 year unsupervised probation to agree to the battery intervention program, which he's already enrolled in, the standard court costs, and a suspended sentence of 60 days with 2 days time served.
Well, I don't have a problem with any of that, but my problem is if it's non-reporting unsupervised probation, who the heck's going to monitor this?
Your Honor, at that point, I believe if he doesn't complete or show proof to the state attorney or I assume it's the state attorney's office at that point, by the end of the year, that he would be in violation of that probation.
So that all sounds good in theory, but Mr. Bird is my 25th prosecutor since I've been on the bench. I don't know if he's going to be here in a year.
Yes, sir.
So I don't know who's going to babysit this thing to make sure it's done. Yes, sir.
Your Honor, I will personally make sure that it's done. We are also handling a court case, which is where it's stemming from.
Mr. Veteran, with that assurance, I'll go ahead and do what you're asking me to do. So ladies, this is going to be unsupervised probation. And Mr. Colley, you would enter a plea to charge. No contest. Let me get you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, help you out? Yes, sir. Put your hand down. Please tell me your full name.
James Terry Colley, Jr.
Mr. Colley, how old are you, sir?
35.
And what do you do for a living?
I am a auditor of the city bank.
What is your educational level?
I have an associate's degree in business.
Have you ever been treated for any mental illness?
No.
Are you now under the influence of any intoxicants? You told me that you wish to enter a plea of no contest to charge with violation of injunction for protection against domestic violence. This is a first-degree misdemeanor for which you could be jailed up to a year, you could be fined $1,000 for both, or you may be considered for a lesser sentence or probation. Do you understand that by entering this plea that you're giving up your right to have a trial on this charge, to be presumed innocent until proven guilty, to be represented by your attorney, and if you could not afford your own attorney, the court would appoint one to represent you? Have you discussed this fully with Mr. Veteran, your lawyer?
Yes, sir.
And are you satisfied with the representation and legal advice that's given to you?
As long as I have legal advice, I'm okay.
Well, there's going to be some court costs involved. You're going to have to complete the battery intervention program, pay some court costs, have no violent contact, and if you don't do that, you'll be sentenced to 60 days in jail. Will the state please proffer the facts?
The state was able to prove that on July 20, 2015 through July 29, 2015, and on various cases between July 20, 2015 and July 20, 2015, in the county of St. John's, Florida, defendant did intentionally unlawfully having been served with an injunction for protection against domestic violence.
violated that injunction until you make it going the remaining employment period of this police session. Any objection to those facts, Mr. Bedford?
Yes, sir.
All right, the plea is accepted, adjudication will be withheld, which means this is not a criminal conviction on your record. You'll be placed on 12 months of unsupervised probation with early termination if you complete everything earlier.
44 weeks in the Constitution.
What's that, sir?
44 weeks in the Constitution.
Okay. You've already signed that and started? Okay. So if you complete the class, it's your court qualification to be off this probationary period. And Mr. Bedford, upon completion, if you want to submit a termination to me, I'll be glad to sign that.
Yes, sir.
All right, the court cost in this particular case is $474. I'll give you 180 days to pay that, so you've got plenty of time to pay it as a condition.
I have $500 bond can be used.
Yep, we sure can. So that cash bond will be used, any balance will be refunded. So you're all paid up, so really all you got to do is class. Yes, for the third time. So in addition to that, you have no violent contact with Amanda Danzinger. And this will be subject to a 60-day suspended sentence with 2 days credit for any time you serve. You'll have 30 days to appeal. If you decide to appeal, if you can't afford a lawyer, I'll tell one. After you sign this, you will be fingerprinted for the judge and the sentence. We'll give you a copy. And Mr. Veteran, if you will submit to me a termination of the probation along with a copy of the certificate of completion, I'll be glad to get that signed for you.
Yes, sir. And just for the court's knowledge as well, the case that this is derived from, there was a permanent injunction entered, and he is required to do this VIP course. So he's got 2 incentives to complete this course.
Well, now in the injunction, is it a no violent contact or is it no contact?
I believe it is a no contact period.
No contact.
There is a specific provision, and here is what was placed in his bond condition. They have children together. They are allowed to communicate for the children. However, that particular injunction does prevent him from having contact unless it's in regards to the children.
Well, obviously there's no violent contact as well, but if he violates the conditions of the injunction, he has a separate criminal charge. He can also be charged with and held in contempt and sentenced to 179 days in jail for a contempt charge. So I would suggest you abide by the conditions of the injunction, and as long as you abide by that, that won't be an issue in this particular case. Come on, sign this, sir. Good veterans out here.
That's all I have.
Thank you. Good to see you.
Thank you. Well.
Thank you.
You're welcome, sir. Next case.
Next case, Judge, I'm Fairbanks.
All right, you can call you.
No further questions, Judge.
Mr. Wood, any cross-examination?
I do have some. Good afternoon, Judge.
Afternoon, Mr. Wood.
Good to see you as well.
Thank you.
Let me go through some questions with you about that particular day. It looked like there were some folks that were in the, for lack of a better phrase, in the audience. Was it fair to say that you had more than one case going on that particular docket?
It was a very light docket, but there were other people in the courtroom, yes.
Okay. Now, I'm sure the jury has never witnessed that in your plea colloquies and your proceedings before it, the time frame for this particular plea, is that about kind of the normal time frame for a plea dialogue?
Pretty standard, yes.
Okay. Now, I don't know if the jury could hear it or not, but you said something to Mr. Colley in response to something he said for the third time, yes. What was he talking about there?
He asked me 3 times if he could be off probation upon completion of the classes. That's the 27-week Veterans Intervention Program.
Okay. All right. Now, you talked about in direct examination that there have been times when you've, had defendants take a breath test when you've suspected that there's some impairment there. Would it be fair to say that those are occasions when there's an outward appearance of impairment that rises some concern to you about the the ability of the defendant to understand the proceedings?
Sure.
Okay.
You know, whether it's the way they're talking, the way they're fidgeting, the way they respond to my questions, the questions they may ask me, it may give rise to suspicion they're under the influence of something.
Now, where Mr. Colley was standing during at the podium there for the plea dialogue, is that the usual distance? I mean, they don't ever get close enough to you than that when they're doing a plea dialogue in your court, is that correct?
No, I have them stand at the podium, and the distance between the podium and where Judge Moss is sitting is about the same as it would be in my courtroom.
Okay. Now, so if someone had come to court and had consumed, controlled substances prior to coming into your courtroom, you would not know that unless you saw signs that rose some concerns in impairment issues. Is that correct?
That's correct.
I mean, because otherwise you wouldn't, drug test them, you wouldn't have any reason to do a blood test on them unless you saw something that was suspicious. Is that correct?
That's correct.
Okay. So you would have, for this particular case, you would have no way of knowing, based on your observations, whether or not Mr. Colley had in fact taken a controlled substance like Ambien before he came to your court.
I saw no outward signs that he was under the influence of anything.
And I mean this certainly with all respect, but do you have any training in psychiatry, pharmacology, anything like that?
I don't, just human observation.
Understand.
And I see a lot of humans.
Yes, sir. Thank you. All right. I don't have anything else. Thank you so much, Judge.
My pleasure. I can redirect this time.
Hey, Ron.
Is Judge Tinlin excused?
He is.
Judge Tinlin? Is that correct? And then you'll be done with your rebuttal? Yes, sir. Okay. So we're going to go ahead and break a little early today, and then you'll be able to rebuttal with us tomorrow morning. Let me talk about tomorrow a little bit with you. It appears that we're going to finish all the evidence and testimony relatively early tomorrow. What's going to happen after that is the lawyers will give you their closing arguments, and then I'll give you the final instructions you need to follow in determining your verdict in this case. If it's around 2 o'clock or so, I'll give you the case to deliberate tomorrow afternoon. If it gets much later than that, then it will be the next day. I don't anticipate we'll have a problem getting it to you tomorrow to deliberate. With that in mind, the same rules are going to apply that applied when we were at the end of the first phase of the trial. Should the jury be unable to reach a verdict after the first day of deliberations, you would have to be sequestered overnight. So I will ask that when you come in tomorrow, we'll have that same parking arrangement that we had last time, that same spot with the deputy with your car, keep an eye on your car. Also bring a bag, an overnight bag, in the event that it becomes necessary that you have to stay overnight for an overnight sequester. And I will let you deliberate for as long as you need tomorrow, and then if necessary, obviously the next day, as long as you need to, obviously no rush on that. Same thing with regard to the phones, tablets, and electronic devices. You can't have those with you when you deliberate. So if you want to leave them in your car tomorrow morning, of course you can do that. But if you want to bring it with you as well, that's fine. And then we'll have a deputy that will be able to secure that while you're deliberating. So that'll be the directions for tomorrow morning. Hopefully, if everything runs on schedule, I'll be able to give you this case to deliberate sometime around 2 o'clock. Like I said, if it gets much later, then we have to bring you back Thursday to do that, but I hope that doesn't happen. Let me give you the same instruction that I've given you every day for the last couple of weeks now. Don't discuss the case with anybody overnight. Don't do any research of any type. And please don't watch, listen to, or read any media accounts of the case overnight. We'll ask you that same question in the morning. And you'll need to leave your notes here in the courtroom. So with that, I wish you a good evening. Tomorrow morning, 8:45, same time, same place, 30 miles. We'll see everybody in the morning. Have a good evening.